Lordship by offering colour. Thank you very much, sir. I now request Learned Director, sir, to kindly give a word of welcome to Learned Resource Person and to Learned participants. Please, sir.
Good morning to everyone present here. In this momentous occasion, we are privileged to have my Lord, Honorable Mr. Justice Bhaskar Pradhan, Judge High Court of Sikkim, Chairperson, Judge in charge Sikkim Judicial Academy. His Lordship, in spite of having heavy pressure of engagement and busy schedule, has been kind enough to share the most precious and valuable time with all of us here to conduct 2 sessions of today's program. I, on behalf of Sikkim Judicial Academy, would like to extend warm welcome to His Lordship and extremely grateful for being with us to conduct today's session as a resource person. I welcome you, Lordship, once again, and I equally would like to extend cordial and affectionate welcome to all officers present here. We have come from all districts of the region of the state, physically as well as through virtual mode. I once again welcome all our officers. Without now further ado, I would like to request His Lordship to kindly guide and lead us on 2 sessions of today's program. Thank you. Please come.
Of the information that I have gathered during the process of learning, it's always been my desire to be a little more curious than everybody else, and therefore I keep doing this research and gathering information, and I thought I gathered enough information to share it with you. This is not to tell you how to write judgments. This is not to tell you that my style of writing judgments are better than yours, or yours is better than mine. It is not to tell you that there is specific styles of writing judgment. It is more of sharing the information that I've gathered over a period of time, and then to discuss with you how to evolve ourselves and make ourselves better. While doing so, I may be a little critical, and pardon me for doing that, but I'm known to be blunt, and I'm sorry, this is how I am. When I started off learning about these topics, I had this mess of information gathered from all over the place, scattered, disjoint, but I gathered information from every source that I could lay my hands on. Ultimately, when I was ready, there was a neat compilation of the 2 topics we have before us. One is judgment writing and law of marriage and divorce in Sikkim. Now, why I say this is judgment writing is precisely this process. First, gather information, facts, law, understand it. Then it's all in your brains. It's scattered. When you have too much information, your mind is a troubled mind. Now you got to regulate that mind, and option would be relevant for you. This is exactly what I think we are required to do. At the initial stage, we need to gather our informations, understand the laws that would be and may be involved. Then churn out the issues that are involved. Understand the facts precisely. Now, understanding the facts precisely is very, very relevant. And therefore, I may get a little critical here. In many of the judgments, and I read each of one of your judgments, I have this habit of making sure that I read it and understand it, because I am, whether you like it or not, in charge of this Judicial Academy, and therefore your improvement is my responsibility. Now, am I mature enough? Do I have that experience enough? No, I do not. Right? I need to learn more. But I think it is important for me to tell you where you are going wrong, how you are going wrong, and how we could regulate ourselves. Okay? In some of the judgments I have read, I have noticed that you do not maintain chronology. Now, chronology is a very, very important aspect of fact-finding. If you do not put your facts in the chronological order, then the information you have may be correct, but how you perceive that information will be totally wrong. I hope I am making myself clear. In many of your judgments, I don't see that chronology at all. As a young lawyer practicing in Delhi, this is exactly what I was taught by the learned senior advocates who I had the occasion to discuss matters with. The first thing they ask for is a chronology. And it's a habit I have inculcated over these years. Even now as a judge of the High Court, what I do is, the first thing I do is, I put things in chronological order. The petitions which have been filed many of them are not filed by trained lawyers. They are not trained minds. They have a whole lot of information, just much like this, and they put it all together. Sometimes accidentally, sometimes intentionally. Information, when comes in a different way, may look completely different. I'll give you an example. Before an order is passed, let us say the law requires a show cause notice is to be issued. Right? Now, in the facts of the case, it could be that the show cause notice was issued and the order was passed. The lawyer who is presenting that petition before you may accidentally not file the show cause notice, or file the show cause notice after the order. So when you look at your petition, the narration in the petition, it looks as if the order was passed without the show cause notice. He may in the courtroom come and complain about it and say that this is what exactly happened. If you look then at the documents, the way the petition has been filed, Annexure 1, Annexure 2, Annexure 3, Annexure 4, Annexure 2 may be the impugned order, and Annexure 21 may be the show cause notice. You understand? So what happens is, what is reflected before you are the complete set of facts in a wrong chronological order, giving an impression that there is a cause of action, and therefore you pass your orders. That's where we go wrong. Now, if you take this exercise, the petition has been filed as it is. You can't do much about it. That's the job of the advocates. But once the documents are there, you can put a chronological table to it. All that you need to do is look at each of the documents, put it in a date-wise sequence, and then read it in that manner. If you do that, you understand the story. And it's so important to understand the story, because each case is a story. Many of us, I don't know, when you read novels, we have this habit. We read the last first, and we sometimes read in between, and then we understand the story completely, isn't it? Because that's our training. We do that. Skip couple of pages, I understood this, come to the couple of pages, and then the whole novel is read. Right? That's how we do. That's the training that we have. But when you listen to your stories, when your parents told you stories, when your uncle, when your aunt, when your elder siblings told you stories, the stories which fascinated you were the stories told in a sequence. It had a beautiful start, it had a beautiful middle, and it had a beautiful end. That lingers on. You remember those stories. Precisely this. Now, the story of the person who is before you. What is the grievance? Unfortunately, in our system of administration, we are told to speak in the English language. The narrative is in the English language. It's not our mother tongue. Right? My English is different than yours, your English is a different manner, yours is better than mine, I'm better than yours. It goes on, but we are not masters of the language at all. So the narrative in the petition may not be the way you perceive things to be, how you understand it. Your understanding itself could be lost. Maybe there is a fault in yours understanding, or maybe very important, the story is the story of the person's grievance, and that's what you need to do. Now, when we talk about judgment writing, my experience is that the judgment writing doesn't start when the arguments are made before you. The judgment writing starts as a trial court lawyer from the day the petition is filed. Much of us, we are very busy, we have very little time, too many cases, too many things to do, administrative work, High Court is putting pressure on me to do this and do that, and therefore I don't have the time at all. So we will keep the judgment writing in the end. The trial will happen. How will the trial happen? Let's understand the practical difficulties. Okay? 2 witnesses are examined today. 20 days later, another 2 witnesses. Another month later, another 3 witnesses. Being told in disjoint fashion. When it is an interesting book, what do? You feel like reading it till it finishes, isn't it? Then when you read it from the start to the end, what happens to you? You understand it so well, it remains with you. But when you understand the story of a person who has come to you for seeking justice in this fashion that we do today, how do you write a judgment? I do not understand this. Isn't it difficult? 1 witness, yeah, you forgot. There are 10 other witnesses for some other case. Then another witness later on, after 2 months. Then another 20 witnesses for some other type of cases. In the end, you are to write a judgment. So you put all your papers together, take this paragraph from here, take this paragraph from here, take the witness statement from here, take another witness statement from here, put all of it together, and in the end, give your view. 20 pages of judgment. Ready. Is much more than that. And judgment writing, therefore, please start right in the beginning, when the cases are filed before you. Start perceiving how it is. So when you put your mind to it, when the witnesses are coming before you, you know exactly what the case is. You know all kinds of cases. In between some election petitions, in between, I don't know, all kinds of things. So there's a whole lot of confusion. But then you need to manage your board. We have no choice. Whether you have 1 case or 200 cases, we really don't have a choice. Because what we have done and what we sometimes forget is we have taken an oath to do justice. in the beginning. You will find in this compilation, which I've given, there's a whole lot of renditions from different courts, how they think that what should be the precise nature of judgment, what should be the beginning, middle and end and all that. What is not there is something which I need to ask you. When you write a judgment, there is a beginning, there is a middle and end. What else is important according to you? The very soul of this judgment. Without the soul, what is the point of having the beginning, middle and end? You must have a soul. The soul is your application of mind, how you are desirous of delivering justice. That's the soul. The soul is your deep understanding of the facts and the law. The soul is the creative mind. The mind which says that this is how we need to resolve this problem. Each case before you is a problem. It is not, as we keep saying, it's a legal issue, it's a factual issue. I don't like these kind of things. What I feel is you got to understand the facts in the perspective of the litigants which are before you. They may not tell you in the manner you're trained as a judge or trained as a lawyer. They cannot tell you. How do you expect a lay person to come and tell you the story in the manner that you have learned? They will tell you in fragmented sentences. They will tell you in rustic languages. They will tell you in disjoint sentences. They will tell you in half-truths. They will tell you in truths which are garnished. They will tell you in truths which must be read between the lines. Each witness, each person who comes before you, okay, are molded in a completely different matter. They are not trained like you. They come from different kind of upbringing. They come with different kind of understanding. They come with different kind of learning. They've come with lack of education. They come without the training of a trained mind like yours. So when you are expecting these petitions, these witnesses to speak in your language, then I think we are not trying to understand what they are trying to say. That's the soul. The soul of a judge is your deep desire to understand the problem and resolve it. And you cannot do it in the end. You cannot do it after 2.5 years of trial. Get all your papers together, bundle it together, take it home, call your stenographer, start dictating your judgment. No, it cannot happen. You start from the very beginning. Put your mind when the petition is filed. Understand what is the problem then. So when you are conducting the trial, till the judgment writing, you've understood the problem precisely. That's the soul that you have to seek within yourself. Until that soul is resurrected, no matter how hard we try, how beautiful our language is, how precisely we have understood the law, how well you have captured the facts in your narrative, it's a well-written judgment. It is not a good judgment. My understanding over the last couple of years, when I started off, I joined the bench as a senior advocate with quite a vast amount of practice. I thought I was a hero as far as being a lawyer is concerned, is it? So when I came and became a judge, I had a lot of information. I had a lot of understanding of the laws. And if you read my previous judgments, this is precisely what I was trying to do. I was trying to impress upon all of you readers that I am a good lawyer. I have understood the laws well. There's a whole lot of things that I've learned over the last 27 years and which I want to now tell you. This is my learning. So if you read my previous judgment, I will explain to you not the case, but the law. And every sentence I come out with a new concept of law and I explain to that. A lot of my lawyer friends at the initial stage said, wow, wow. They said, wow, now we have a good judge. You know. Today, I feel I was wrong. So what I'm trying to tell you right now is my limited understanding of the last 5 years as a judge, of understanding how things must work and where we are going wrong. I want to tell you my own story so that you understand where we went wrong. So sometimes if you read my judgment, it is more the command over the language, my poetic genius, my mastery over the language, my learnings of the literature, my learnings about the law. It was about me. Those judgments, if I read, are my stories. It's not about the problems. Maybe I wrote the correct judgment. Maybe, it was upheld by the Supreme Court. Maybe that it was the correct thing to do, right? But it was more about me. Today, when I look at cases, I feel I have transformed myself dramatically. I am more conscious about the fact that of all the shortcomings that may happen during the course of judgment writing, which means from the beginning to the end. And I have course corrected. I think all of us at one point of time need to do that. Yeah. So if you take out this compilation, which I have put together, and I'm sure you will add more to it, it's just my thoughts which are there. I've given a small little summary for you to read in your spare time if you do have the time and the inclination. And also, I try to make my judgment live. I start my judgment, as it were, with a prologue, as the chorus does in one of Shakespeare's plays, to introduce the story. Then I go from act to act, as Shakespeare does, each with it, scene drawn from real life. I finish with a conclusion, and epilogue, again as the chorus does in Shakespeare. In it, I gather the threads together and give the result. This is what Jennings said years ago, right? Now, according to me, what are the ingredients of a judgment? There must be an introduction, then setting out the facts, then the law and the issues, applying the law to the fact, determining the relief, including cost, and finally, the order of the cost. Now, again, this part of introduction is according to, again, this is my perception. You don't have to really, how I feel is, when you're writing a judgment, write the introduction in the end. That's how I want to do it, how I would do it. So I write the setting, I set the facts, right? I state the law, I state the issue, I apply the law to the facts, I determine the relief, including cost, and finally when I write the order of the court, I know exactly and precisely what the case is about. So then I put in an introduction. The first paragraph, when I give an introduction, right, I will tell in a summarized form precisely what I was called upon to look at, what did I look at, and how did I conclude. So one glance of the introduction will give you exactly your mind. It makes it interesting for the readers to read. And mind you, when you are writing a judgment, don't write it for yourself. Write it for who? Who is your audience is the question you need to ask yourself. Who is your audience? Many of you will say the High Court. That was a joke, right? But we are worried, isn't it? That's back in your mind. Huh? The High Court is looking at us, and therefore I am writing a judgment, of course for the litigant, but in the back of our mind is the High Court. Don't be bothered about the High Court. Bothered about doing justice. Right? Many of our views which we thought was correct has been corrected by the Supreme Court. Those of the views which are, which we have upheld of yours, right, has been course corrected later. Those are the views we have set aside of yours, has again been course corrected by the Supreme Court. They say, no, the district judge was right. The district judicial is right, you're wrong, they say. And we've course corrected. So don't bother about it. What if your feeling is true, if your desire is truthful, if you have searched for the facts correctly, you found the truth, and then you've given an answer, do not bother about what the High Court is going to say. Because you've done justice. You may have written a wrong order, but you've done justice. So when you are writing your judgment, write it not for the reader in the High Court or the lawyers before, learned advocates who come and give you beautiful, judgments. And Mr. Pradhan was like one of that. He would come and, give his story, and he's a good storyteller. So when he'd argue before the learned judges, people would be convinced with his story. His story, he himself knew whether it was true or not. But then that's what he did. And many of you judges, were convinced by him. Now that's the real job of a lawyer. But the real job of a judge is not that. It is about doing justice, isn't it? So when you try to do justice without knowing the facts correctly or in its correct perspective, in the correct chronological order, it can never be right. You've never got it right. So you got to be very, very careful about this. Now, I put a flag A to this judgment of Joint Commission of Income Tax Surat versus Saili. I have also, extracted that portion if you read what the Supreme Court says. These guidelines are only illustrative in nature, not exhaustive, and can further be elaborated looking to the need and requirement of a given case. It should always be kept in mind that nothing should be written in the judgment order which may not be germane to the facts of the case. It should have a correlation with the applicable law and facts, and ratio decidendi should be clearly spelled out from the judgment order. After preparing the draft, it is necessary to go through the same to find out if anything essential to be mentioned has escaped discussion. The ultimate finished judgment order should have sustained chronology, exactly what I said. Regard being had to the concept that it has readable, continued interest, and one does not feel like parting or leaving it in the midway, like a good storyteller. To elaborate, it should have flown and perfect sequence of events which would continue to generate interest in the reader. So what the Supreme Court is calling upon you to do is to be a good storyteller, isn't it? Appropriate care should be taken, not to load it with all legal knowledge. And many of us suffer this problem. Many of us. Okay? On the subject, a citation of too many judgments creates more confusion rather than clarity. The foremost requirement is that leading judgment should be mentioned and the evolution that has taken place ever since the same were pronounced, and thereafter latest judgment in which all previous judgments have been considered should be mentioned. While writing judgment, psychology of the reader has also to be borne in mind, but the perception on that score is imperative. Language should not be rhetoric and should not reflect a contrived effort on the part of the author. Many of us suffer from this as well. After arguments are concluded, an endeavor should be made to pronounce the judgment at the earliest. Please keep all these things in mind. And in any case, not beyond a period of 3 months. Keeping it pending for a long time sends a wrong signal to the litigants and the society. It should be avoided to give instances which are likely to cause public agitation or to a particular society. Nothing should be reflected in the same which would hurt the feelings and emotion of any individual or society. Very nicely put. I would like to emphasize on a couple of things out here. Number one, don't clutter your judgments with unnecessary facts. So read A and B together. A is basically put germane facts, put it together. Unclutter. This whole lot, discard if you need to discard it. What is the issue? Therefore, it is very important for us to understand the issue. What are we called upon to do? What is the relief they are seeking? While, when you are writing judgment, you write judgments on various aspects, at various stages, So you will be writing a judgment in the end of the trial, in both civil and criminal cases. You will also be writing your orders, which are also judgments, when at the interlocutory stages, when you are asking for interlocutory relief, when you are when you directing the appointment of a commissioner, when you, so many things, or taking custody of certain things, or giving custody of certain things. But when you are deciding a stay application, then the consideration at that stage would be different from the stage when you are deciding the final case. In many of your orders, you come to a conclusion, you say what you have to say, you narrated certain facts, and then you come to your conclusion. Many of the times your conclusions are right, you are very trained legal minds, so therefore you come to the right conclusion. But your judgment must also reflect your understanding of the issue before. You need to work a little harder on that. Okay. Many a times I've seen that you've heard the parties, you've understood the point which the learned counsels are telling you in the courtroom, and then you give your judgment, and then you pronounce, maybe correctly, maybe incorrectly, but you just make that statement. But if you read the application and then you apply the law, then you realize maybe the lawyer could not tell you the correct facts. I've seen it in your orders. And therefore I'm telling you, I've seen it in your orders, that the application is saying something, the lawyers are saying something, because you've written it in your order, that this lawyer argued this. And this is my thought. Right? But then I look at the application, because I'm asked to read it, when in appeal, and I read the application is something completely different. And then your focus therefore has been shifted from the real issue, the germane issue, and you have been shown certain facts from the thing. You know it is an interlocutory application. I don't need to read the entire text of the petition, the entire the documents that have been filed, and therefore you go by the learned counsel and you come to a conclusion which perhaps you are not even asked to. So your conclusion is more based on what has been argued before you than what was the grievance of the petitioner. Again, you have to be a little careful while dealing with such issues. Right? It could be that the application contained several issues, and it could be that later on they said, no, all these issues are not important, only 2 issues are important, and that's what you are called upon. When the lawyer says that, put it in your order. This is what I was asked to do. I don't see that. So, when it comes to an appellate court, you see the appellate court is a little confused, because an application has come which seeks A relief. The argument which has been placed in your order of the council is seeking B relief, and you are given B relief without explaining why you are giving B relief when you are the applicant, under the signature of the applicant, is asking for A relief. Right? Now, therefore, when you are writing an order, why I am trying to tell you this is, when you are writing an order, or when you are writing a judgment, more when you are writing a judgment, but even when you are writing an order, the reasons for your order is important. You are not sitting in the darbar. You are not sitting as the king. I hereby grant you. If you have that feeling within yourself that because you are sitting in a high chair, much above the rest of the lay person, I am the king or the queen, and therefore I can grant you the relief that you seek, then get it out of your head. Get it completely out of your head. You are not there. You are a servant of the people. If you don't like that word, don't be a judge. You are a servant. I am a servant. I'm here to serve the people. I am not the high and mighty. I am not the flag which flutters in front of me in my vehicle. I am not the chakra behind me. Please understand, there's a distinction between what we ride on, what we sit on, and what we are. If you have remotely a feeling that I am high and mighty, please get it out of your head. Because if you do that, you cannot be a judge. You cannot be a judge. You as a judge are entitled to a lot of things. I hate this word entitlement. You're entitled to a lot. So when the service is taken out of your head, no matter how beautiful your language is, many of you are from public schools, you speak well, you come from very affluent backgrounds, and therefore you have beautiful flourish, you have everything that you need. You wear good clothes, lovely yellow tie. I wanted to tell you this, right? But this is not what I am when I am in the courtroom. I need to be humble. I need to be a judge. I need to understand the plight of the people. I need to understand what is your pain. I need to understand what is it that troubles your mind. And like a good doctor, remove that pain. Give them that relief. Like a good doctor. if there is a little tumor in the mind, the poor person is not being able to think. Put yourself in a situation. I've been in a situation like this. I've been dragged into litigation. Not because I desire it, because somebody thought I should be in a litigation. I'm telling you my own story. I fear litigation. Each time there is a call of that matter, I worry. And I'm sure it happens to you as well. Imagine that litigation. He's in the same state of mind. He's troubled. He's so desperate he can't resolve it. He's coming to you for help. तपाईहरुको काम के हो? चेयरमा बसेर धमास दिने, चेयरमा बसेर गाली गर्ने, चेयरमा बसेर करेक्ट गर्ने कि जस्टिस दिने? All of us, I mean, I'm not putting myself in any other place. I'm also like that. But we need to think. We need to think. What are we here for? What are we meant to do? What we need to understand. What we need to do. And that's the soul that I'm seeking from you. Your good English will not help you. Your great learnings will not help you. I'm telling you very, very frankly, unless you learn to sit along with the litigants, be in their place, understand their pain, their plight, and resolve that issue. You need to be a surgeon. Because when you render your judgment, the litigant must go back home feeling a relief of the little tumor that was in the brain and was taken out. But a good surgeon, even if there is little pain for a couple of months thereafter, when it heals, you will be a new person. Do you intend to do that? Do you desire to do that? Do you feel it is important to do that? Is the question that I want you to ask yourself every time that you write a judgment. Every time you write an order. Some of you may think that, this man is, sitting and in the high chair of a judge and therefore speaking. We don't have the time or the time to do that. There are so many litigants that before me. How do I? And I have to go back home and resolve my issues at home as well. I mean, I can't be impractical like him. It could be in your mind. And you may be right. But my request to you is push yourself that much harder. Because this is the only course which is the correct course. There cannot be any other way. And I'm absolutely clear about this. So when you are reading all these things, introduce another thing, the soul, in object. So in law, it is the affirmation of the law of the legal consequences attending a proved or admitted state of facts. It is always a declaration that a liability recognized as within the judicial sphere does or does not exist. A judgment, as the culmination of the action, declares the existence of the right, recognizes the commission of the injury, or negatives the allegation of one or the other. A judgment of a court is an affirmation by the authorized societal agent of the state. Now, so beautifully put. A judgment of a court is an affirmation by the authorized societal agent of the state. Who is this? You, me, right? Speaking by warrant of law and in the name of the state of the legal consequences attending approved or admitted state of facts. It is declaratory, determinative and adjudicatory function in its distinctive characteristics. It is Its recording gives an official certification to a pre-existing relation or establishes a new one on pre-existing grounds. Then I have put this judgment as flag C. If you just quickly turn the page to flag C, I put this case before you because many a times we may be faced with the same kind of situation. I would request you to read the entire judgment. For now, I will just read the head notes. Okay. Whilst pronouncing judgment, trial judge only dictated operative portion during lunchtime, after which, without dictating judgment to stenographer, transcribed and signed the same and made endorsement in plaint docket sheet that plaintiff in suit was not entitled to specific performance of sale agreement but was entitled to refund rupees 2 lakhs, validity of held order 20 rule 1 postulates that after case has been heard, court hearing same shall pronounce judgment in open court by dictating to shorthand writer. Mere fact that a major portion has been dictated by judge will not by itself lead to conclusion that judgment has been delivered. Undisputedly, trial judge has not completed judgment before he delivered his decision. Matter remanded for rehearing and decision afresh. Next, head note. Requirement of a valid judicial determination explained. Declaration of operative order orally followed by written judgment, impropriety, CPC, held, does not envisage writing of a judgment after deciding case by oral judgment. It would be against public policy to ascertain by evidence alone what judgment of court was, where final result was announced orally, but judgment as defined in CPC embodying a concise statement of case points for determination, decision thereon, and reasons for such decision were finalized later on. Held. The ultimate question is whether in the instant case the judgment has been validly delivered. It is the mere procedural irregularity and the judge concerned had not signed the judgment. Then the judgment thus rendered cannot be invalidated. The mere fact that a major portion has been dictated by the judge in the judgment already dictated will not by itself lead to the conclusion that the judgment had been delivered. The declaration by a judge of his intention of what his judgment is going to be, or a declaration of intention of what final result it is going to embody, is not a judgment until he crystallizes his intention into a formal shape and pronounces it in open court as the final expression of his mind. CPC does not envisage the writing of a judgment after deciding a case by an oral judgment. It must be resorted to, and it would be against public policy to ascertain by evidence alone what the judgment of the court was, where the final result was announced orally by the judgment as defined in CPC, embodying a concise statement of the case, the points for determination, and sign and deliver. Right? Please do it in open court because it is a public fora. You need to pronounce it in open court. You need to tell them that this is our view. I have applied my mind. There are doubting Thomases. There are people who doubt every act of yours. No matter how clean you are, no matter how clear you are, there will be people saying things. Right? Our institution survives on public perception. If the public perception fails, no matter how beautiful the judgment that you write, it has no meaning at all. It has no relevance because you've lost that perception battle. So if they think that you are not a good judge, no matter how beautiful you write the judgment and how correct it is, the High Court is upheld, Supreme Court is also upheld. To that person before you, where you have lost in the perception battle, it has no meaning. Firstly, the litigants many of the litigants that come before you do not understand the language at all. So your 10 pages judgment, 20 pages judgment, 30 pages judgment will have no meaning. Okay? The meaning will be, again, explained by the lawyers. The lawyers have to save their own skin as well, right? So they'll say exactly what they want to say, and they will withhold certain things which they don't want to say, right? So what the litigants takes away is what you need to worry about. So judgment is not about judgment writing alone. Judgment is what you are doing before the court, how you are acting before the court, how you are presiding over your court. Because that is where you will win the perception battle. If you act as a good person, if you are humble, if you are attentive, the litigants for whom you are sitting in that chair, over the period of time when the trial is on, you have won the perception. That judgment which you deliver thereafter is a judgment which will be accepted by the litigant. It will be respected by the litigant. And there you will win as a judge. But if you are obnoxious, you don't have time, you're rude, you don't have that time to listen to this nonsense. I don't know what nonsense they keep speaking in the courtroom. Well, if they could speak like you, then they would be sitting in your chair. Then they would be troubled. They don't know how to speak like you. That's why they are there. So you got to understand that. Don't expect them to be you. But because you are the judge. Understand them. Win that perception battle. And when you win that perception battle, you will render justice in the end of the trial. And keep this in mind, because according to me, at the cost of reputation, judgment writing is not about beautiful text. It is the entire process, starting from the time of filing of the litigation, which comes before you, and ultimately when you deliver justice. In that WhatsApp, sometimes you keep getting these little clips of this judge from the US, some court, and have you seen him deliver? What do you think? What do you think? How did you perceive that judge to be? Is there a desire to be like him? What do you think? Please tell me. You've seen those video clips, right?
I've seen some video clips from Bihar or
As well.
Always
No, I'm not. I'm not on that. I'm talking about that American judge. He does all these petty cases, those motor vehicle cases,
Yes.
right?
So he asks the person what happened, how he is, and what the. Sometimes it,
What is your perception of that judge?
He's very kindly when he has the time to like listen.
Kind, humble. He has good ears. That's right. That's right. So therefore he has these flaws. This is what I'm trying to say. I'm trying to bring that out. I'm also saying that some of the judgments he passes, the orders that he passes, it may not be acceptable to you. Right? But you never question his integrity. I have not. I've seen many of them. A huge number of them. I have never questioned his integrity. And that's where I think institution is not by any sword or any weapon that we use strong. It is because of how we render justice that makes it strong. So when you are writing judgment, keep all these things in mind. Least of all should be your bother that the High Court is watching over us, or the Supreme Court is watching over us. if I were to write judgment based on what the Supreme Court is going to think about me, then I would never be doing justice. Never, never. I cannot. Your opinion may be different than mine, my opinion may be different than the Honorable Judge of the Supreme Court, and the Supreme Court opinion may be different from us. Our opinion may be different, but there has to be one thing common in all these. What is that? Our integrity. Our integrity to do justice. Our thought must be clean. If that thought is clean, no matter how you write the judgment, you will win the perception battle. And this perception battle is an integral part of your judgment. Then we go further. Let's go to the criminal aspect of that. There are a lot of other things which I will skip, but come to criminal at page 4. Now, when you're writing a judgment in criminal cases, keep in mind these sections which I have just placed out there, right? Section 353, it is what the judgment is. 354, language and contents of the judgment. 357, order to pay compensation. Many of you do not write these orders. Now you have started writing on compensation, but many of you don't do that. Please pay a little more attention to this aspect of it. Compensation to be in addition to fine under section under section 326A or section 376D of the Indian Penal Code. 357C, treatment of victims. 358, compensation to person groundlessly arrested. 359, order to pay cost in non-cognizable cases. 360, order to release on probation of a good conduct or after admonition. These are again something which we do not give much thought about. Please apply this. 361, special reasons to be recorded in certain cases. 362, court not to alter judgment. This is very, very important. Do not alter your judgments. Please do not do that. 363, copy of judgment to be given to the accused and other persons. Emphasize there, to be given to the accused and other person. 365, court of session to send copy of finding and sentence to district magistrate. The district judges, how many of you, the session judges, how many of you do this? 365. Do you send it to the district magistrate? Have you thought about it? There is a provision, please look into it, examine the provision and then apply it, right? Precedent. This is Yaqub Abdul Memon. Thus, in view of the above, it is evident that generally a judgment must be complete and it must have, take a small little book, I keep making these notes, right? And prove facts, not prove facts. Now, disputed facts. When disputed fact, then I go into understanding the Evidence Act properly. Apply the Evidence Act. How has the facts come in? Whose fact is it? It's very, very important. Is it the plaintiff's fact? Is it the prosecution's fact? Is it the defendant's fact? Is it the defense's fact? Right? Then, if you understand how these facts come in, whose story is it? Then you will understand how exactly it is to be proved. If you don't understand where this narration is coming from, then you put the burden on somebody else. And then there will be a whole lot of confusion in your judgment. So when the facts are being narrated, right, understand the story of the plaintiff, the way the plaintiff tells you. If the plaintiff is saying that this is a book which belongs to me, whose fact is it? It is the plaintiff's fact. Who needs to prove it? It is the plaintiff who needs to prove it. Whose burden? It is the plaintiff's burden. Don't put the burden on the... How does the defendant prove whether the plaintiff purchased this book? Tell me. Think of it. It sounds very simple, but put yourself in that position. Put the burden on the defendant, and now the question is, how did the plaintiff purchase this book? How in the remotest way will the defendant prove this fact known to the plaintiff? Can he do that? You can't prove the negative, can you? In many of the issues I have seen, you put the negative burden on a particular person, and then you have no answer there. And then when you write the judgment, I have seen, suddenly it is abruptly ended. Because you don't know how to answer this now. You put the issue, the burden on the wrong person. So you can't get an answer. Logic must follow. And this logic is very simple. One who states must prove it. If you understand this logic, then there is no problem at all. So when you are framing issues, or the point of determination in criminal cases, you got to understand where the burden lies. In a criminal case, the accused has a right of silence, and the prosecution has the burden of proving the guilt of the accused beyond reasonable doubt. It is the case of the prosecution that A murdered B. It is therefore for the prosecution to prove that A murdered B. Many a times in the judgment you question, the defense has not been able to. He made a statement, defense has not been able to do this. What is the job of the defense to prove the prosecution's case? I ask myself. So be careful with your language. Many a times defense cannot prove certain things. How does he prove the negative? He cannot prove the negative. And then in a criminal case, he is not called upon to do that unless there is a presumption, which is a rebuttable presumption. Right? So when you are making these issues for determination, you also need to keep in mind, what is this case about? Let us say a very simple case that the plaintiff is claiming that this property is his. Right? The defendant is saying, no, it is mine. So both are saying it is theirs. What is the issue here? How will you frame this issue? Both are saying. One is saying, plaintiff is saying that this property is mine. The defendant is saying, no, it is not his, it is mine. So both are making the assertion that it is theirs. What is the issue that needs to be framed?
Plaintiff is the one who has come to the court as a plaintiff. He is the one asserting it at first point. So he is the one who...
Careful with that. I have seen many cases where the issue is, because he asserted that, I get afraid when I make these statements in these kind of forums, one who asserts must prove it. So you take it back home and say, one who asserted, he asserted it, so he also asserted, now I am putting the burden on him. The Honorable Judge of the High Court said it. So be careful, apply your mind, the Honorable Judge, you put the burden on him, the issue is framed likewise. Now, there are, because the Madras or the Bombay High Court or Bombay courts, suits, or the Madras court suits, or the Calcutta court, the suits are 1 page, 2 pages. Our suits are into 200 pages. It has pleadings, it has submissions, it has submissions to the effect that the act is arbitrary, it is illegal, perfect, unconstitutional. All these things come in our suits. That's not the requirement. Why I'm trying to tell you is not to ridicule the learned judge, the lawyers who are doing it, but to be able to make you able to understand, to sift these things. Everything can't be an issue. Whether it is unconstitutional in a suit, what is the constitutional aspect of this? Why are you framing issues with regard to the constitutionality or the illegality of this, or the arbitrary aspect of it? You have to understand the facts. What is the issue? One is claiming property, other one is saying it is not his. So that's the only issue that is there. Related issue, yes, but you can't frame issues like 20 issues for everything that the plaintiff says. So one submission is that it is illegal and arbitrary and unconstitutional. The reply comes from the other side, it is not. So now there is conflict, now one issue is framed. Let us do that in the High Court. You don't need to do that. So don't bother yourself there. Okay? So be very careful when framing issues. Be precise. Again, that's what I'm saying. Judgment writing starts right from the beginning. If you understood the facts, or what the story of the plaintiff is, what the story of the defendant is, then you will know exactly what issues are to be framed. But if you don't understand it, if you just see pleadings after pleadings, because you don't have the time to understand those facts, I don't have the time. I'm writing it in between my first cup of tea and my second cup of tea, or between, parsing orders in 20 cases and then another, what they call warrant case coming before you and the police coming, taking your signatures, then it's a whole lot of confusion. In civil suits, you cannot have 20 issues. It cannot be. But I've seen 20 issues, 30 issues. Somewhere we are not applying our minds. I'm sorry, again, I'm saying I'm very blunt. I'm not pointing out, you did this and you did this. So, give me that discretion. But I'm telling you very clearly that somewhere you're going wrong. Another thing which I have noticed in criminal cases is when you do a 3-on-3. You are doing it horribly wrong. Let me be very blunt about it. You're doing it horribly wrong. Somewhere somebody did it and you are repeating what they did. What you do is you extract statement. And I think you may either weighing it or seeing the number of lines. Because there is no other application of mine. I'm being very blunt with you. Because you take out this much of the statement of a witness. This much of the statement contains 8 different facts. But you're really not bothered about that. You're really bothered about this length. So, 80 nikalanu yahan, no? Then you can 80 nikalanu, then you can 80 nikalanu. So the whole lot of your 3-on-3 is, I went to the Namna, I ate burger there, I met Mr. Pradhan, he said this to me, I saw a knife in his pocket, and he said that I intend to do this. What do you have to say? Poor chap, what is he going to say? He will say, I don't know. And then you write a judgment saying, he lied, I don't know. He's not speaking the truth. And I'll send him to jail because of that. How does the poor man understand what you're trying to say? And what are you supposed to do in a 3-1-3?
Reporting is on.
What are you supposed to do in a 3-1-3? Put the incriminating fact. And then in spite of that I see extract after extract from witness statement. So the entire statement from top to bottom. No, you don't want to leave anybody to doubt your caliber. You don't want anybody to even think that this person has not applied your mind. Every sentence is repeated verbatim from the statements. So the appeal paper book consists of the 164 statement, the depositions, and then repeat depositions in the form of 313. So if I read your 313 questions, I don't have to really read the depositions at all. And all that I see in the answer to the 313 is a confused accused. Somewhere in between, there is a statement, so and so said your name is so and so. The answer is I don't know. I've seen that. And then I've seen judgment also says this guy doesn't even know the name. He's lying, obviously. That's our analysis. We are going horribly wrong. Put it precisely, apply your mind. The incriminating circumstance. Not extract. Who told you that extracts of witness statements have to be put? I can't understand this. Now, if you put the question in this manner, Mr. Pradhan said that Mr. Pradhan is a joker. The question, my request to you is apply the law and do exactly what the law requires you to do. Then the second one. This is this is basically a lecture by Michael Sandel of Harvard University, the moral side of murder. I wanted to, in fact, I don't know whether that's ready. Is it ready? Given just the citation so that it is clear that this law is already settled earlier. So I don't have to elaborate on it. Right? If the party affected signs a written document, knowing it to be a contract which governs the relation between them, his signature is refractable, evidence of his assent to the whole contract, including the exempting clauses, unless the signature is shown to be obtained by fraud or misrepresentation. Again, the citation. But what is sufficient misrepresentation for this purpose? That is the point which Mr. Lawrence has raised in this appeal. So in one paragraph, he stated the facts, he stated the law so clearly, no extracts, nothing, and then the point of determination. Isn't it so beautiful? The way and the language is so lucid and clear thinking. Then, in my opinion, now he gives his opinion, in my opinion, any behavior by words or conduct is sufficient to be misrepresentation if it is such as to mislead the other party about the existence or extent of the exemption. If it conveys a false impression, that is enough. If the false impression is created knowingly, it is a fraudulent misrepresentation. If it is created unwittingly, it is an innocent misrepresentation. But either is sufficient to disentitle the creator of it to the benefit of the exception. See how beautifully he puts it. There is no confusion in his mind. In 2 sentences, he has explained that both these situations would create a situation where the benefit goes to the other side. Right? In Rex versus so and so, it was held that the representation might be literally true but practically false, not because of what it said, but because of what it left unsaid. In short, because of what it implied. This is as true of an innocent misrepresentation as it is of a fraudulent misrepresentation. When one party puts forward a printed form for signature, failure by him to draw attention to the existence or extent of the exemption clause may in some circumstance convey the impression that there is no exemption at all, or at any rate not so wide an exemption as that which is in fact contained in the document. The present case is a good illustration. The customer said in evidence, when I was asked to sign the document, I asked why. The assistant said I was to accept any reasonable responsibility for damages to beads and sequins. I did not read it at all before I signed it. In those circumstances, by failing to draw attention to the width of the exemption clause, the assistant created a false impression that the exemption only related to the beads and sequins and that it did not extend to the material of which the dress was made. It was done perfectly innocently, but nevertheless a false impression was created. It was probably not sufficiently precise and unambiguous to create an estoppel, law versus so and so. But nevertheless, it was sufficient misrepresentation to disentitle the cleaners from relying on the exemption except in regard to beads and sequins. Now, this is all I want to read. I really wanted to read this paragraph to make it clear to you that you don't need to go into explaining everything. If you have understood your case properly and precisely, you can put it usefully and clearly. Clarity of thought is very important. The judge is absolutely clear of what he is required to deal with, what is the issue before him, what was the law as it stood earlier. There is no need repeating the same law again and again. Now that you've understood, apply the law, isn't it? So that is what I think is very important. That's what we all need to learn, including me, need to learn. To be precise in our delivery, we need to be a surgeon. Resolve the issue that is there, which will solve the problem. Issues are not just issues because the law requires you to frame issues. Issues are the pain and anguish of the people before you. That is what you have understood. If you have understood that well, you have put it very clearly and you have delivered your judgment with that clarity of a surgeon. You cannot lose them, right? The other judgment which I wanted to also show you is that with regard to A, that is at page 28. Please go through this judgment and see how the question which we are now very often dealing with in POCSO cases and rape cases of the identity of the victim and how they have put in their judgment. Have you had page 28 before you? If you see at the top, what is the case? It is a child, that's all. Right? Then if you go to the next, the operative, the part of the judgment after Parker, I am concerned with the child A, born on redacted, presently age redacted. The child's father F took the life of the mother M. So what we now do here, which we have started doing, is something which is being done across the board. That is what I am impressed with, right? But just giving you examples of how judgments are rendered in different parts of the world. I'm sure you have access to it. You may not have the time, so I put it together in this form for that you can read it and make your understanding even better. Okay, I think I've spoken enough. anything that you need to ask, anything that you need to discuss, let's talk about it now. The problems, issues that you all face, so that we can think about it and talk about it and resolve issues. The prosecutor perceive me to be. If I ask this question, this side will think otherwise. If I ask that question, this side will think otherwise. No, you are a judge. You are seeking the truth. This whole exercise that is being done before you is to seek the truth. But if the answer is not coming, it is in your head. Question nahi karena. Question, it is there in your head. But you are hesitating to put this question. So in the end of your trial, the answer to the vital question is missing. Then what you do? Because of your great ability as a judge, you now take the exercise of guessing the fact, guessing the truth. Because the answer is not there. Somebody hesitated. The truth is not out. You can't guess the fact. Presumptions are there, the presumptions are already there. It's not a problem. But facts can't be guessed. Facts have to be stated. When somebody is not stating, it's your duty to make sure that it is stated. I have seen in criminal trials with regard to what we call to victims of crime, right? POCSO cases. The father comes. The questions which are asked are everything but about the victim's age. Can't the court ask a simple question? What is the age of your child? Court has the power to do that. Is there a problem there? Why don't we ask that question? Again, you are honorable judges. You have your own minds. I am not imposing my thought in. It's a question I ask myself because I see these in appeals. A document, if you know the existence of a document, like the birth certificate. Now, pray, ask yourself, how do you make birth certificates? All of you have children, many of you have children. How do you do that? Does the child go to the births and deaths of his wounds? One of the parents. So isn't the parent to know about this? I don't see that question coming. Third person, who was the Caesar, he is being asked. But of course it is being done by the prosecutors. But what is the court doing? Aren't you conduct the trial? If the prosecutor is not getting the truth, why are you not seeking it? Are you creating facts? The document is there. Now you're concerned about the authenticity of this document, the truthfulness about this document. You got to search the truth, isn't it? That's your job. The court has been given the liberty to ask questions, court questions. You can exercise that. Just imagine the plight of the appeal court when the learned counsel who appears before the court comes and argues that I am not arguing on anything except the age of the child who is said to be 7 years old. If the trial court could not determine the age of the child who is before you to be 7 years old, how do you expect the appeal court to render a judgment on that? Ask yourself. Isn't the trial court's job to find the truth? The child is, I can understand a 17.5 years problem. 2-year-old child, the learned counsel is arguing. No other point I want to argue except the fact that the child age is not proved. The question we ask from the court is, how old is the alleged age of the child? Lordship, it is 2 years. The audacity of their appeal. Somewhere we are going wrong then. So be concerned about these things. Please be concerned about these things. Judgment is not the thickness of the documents that you write and the lovely English that you do. It is the trial that you do. Ultimately, you are not doing justice. One word, acquitted. One bit, convicted. That's all you need to do, isn't it, in the end of the trial? But the trial is failed. So where is justice? And when there is no justice, where is judgment? What is judgment? The word judge comes in there, isn't it? What is a judge? Be conscious of these words. So if you have not conducted the trial in the manner that is required to be done, in the end of it, doesn't matter. It's not helped anybody except you of disposing cases. Is that all we are looking at? Disposals? Ask yourself this question.
Regarding the residence, so I pass an order saying that even though the matter is dismissed, but she will not be disposed from the house where she is living right now. So, but there was nothing in the pleadings also like that also. Whether this kind of things we can put in a judgment.
In what kind of case?
It was a domestic violence matter also.
So the Domestic Violence Act itself tells you exactly what does it pass.
Yes, but I'm talking about other judgments also. Some other matters, like in civil matters also. Because I thought that
In
even
civil
though...
matters, the law is very clear. You can't go beyond the bare.
Yes, I thought, in this matter, I thought that even though that...
Substantial justice which you are
yes,
talking
yes.
about, this is an area which according to me, is grey. There are a lot of judgments who try to do substantial justice by passing orders of all kinds. But I don't think that would be correct.
Some of the matters, Rajib, we feel that even though the case doesn't stand, but some order needs to be passed.
I can understand the human element in your thought, but then the law does not prescribe that. So we cannot go beyond the law.
Last time, we argued about the case of the Queen versus Dudley and Stevens, the lifeboat case, the case of cannibalism at sea. And with the arguments about the lifeboat in mind, the arguments for and against what Dudley and Stevens did in mind, let's turn back to the philosophy, the utilitarian philosophy of Jeremy Bentham. Bentham was born in England in 1748. At the age of 12, he went to Oxford. At 15, he went to law school. He was admitted to the bar at age 19, but he never practiced law. Instead, he devoted his life to jurisprudence and moral philosophy. Last time we began to consider Bentham's version of utility is to maximize the general welfare, or the collective happiness, or the overall balance of pleasure over pain. In a phrase, maximize utility. Bentham arrives at this principle by the following line of reasoning. We're all governed by pain and pleasure, They are our sovereign masters, and so any moral system has to take account of them. How best to take account? By maximizing. And this leads to the principle of the greatest good for the greatest number. What exactly should we maximize? Bentham tells us happiness, or more precisely, utility. Maximizing utility is a principle not only for individuals, but also for communities and for legislators. What, after all, is a community? Bentham asks. It's the sum of the individuals who comprise it. And that's why, in deciding the best policy, in deciding what the law should be, in deciding what's just, citizens and legislators should ask themselves the question, if we add up all of the benefits of this policy and subtract all of the costs, the right thing to do is the one that maximizes the balance of happiness over suffering. That's what it means to maximize utility. Now, today, I want to see whether you agree or disagree with it. And it often goes, this utilitarian logic, under the name of cost-benefit analysis, which is used by companies and by governments all the time. And what it involves is placing a value, usually a dollar value, to stand for utility, on the costs and the benefits of various proposals. Recently in the Czech Republic, there was a proposal to increase the excise tax on smoking. Philip Morris, the tobacco company, does huge business in the Czech Republic. They commissioned a study, a cost-benefit analysis of smoking in the Czech Republic. And what their cost-benefit analysis found was the government gains by having Czech citizens smoke. Now, how do they gain? It's true that there are negative effects to the public finance of the Czech government because there are increased healthcare costs for people who develop smoking-related diseases. On the other hand, there were positive effects, and those were added up on the other side of the ledger. The positive effects included, for the most part, various tax revenues that the government derives from the sale of cigarette products, but it also included healthcare savings to the government when people die early, pension savings, you don't have to pay pensions for as long, and also savings in housing costs for the elderly. And when all of the costs and benefits were added up, the Philip Morris study found, because you know that if you crash into these 5 workers, you car, and we begin with a story. Suppose you're the driver of a trolley car, and your trolley car is hurtling down the track at 60 miles an hour. And at the end of the track, you notice 5 workers working on the track. You try to stop, but you can't. Your brakes don't work. You feel desperate because you know that if you crash into these 5 workers, they will all die. Let's assume you know that for sure. And so you feel helpless until you notice that there's one worker working on the track. Your steering wheel works, so you can turn the trolley car, if you want to, onto the side track, killing the one, but sparing the 5. Here's our first question. What's the right thing to do? What would you do? Let's take a poll. How many would turn the trolley car onto the side track? Raise your hands. How many wouldn't? How many would go straight ahead? Keep your hands up, those of you who would go straight ahead. A handful of people would. The vast majority would turn Let's hear first. Now we need to begin to investigate the reasons why you think it's the right thing to do. Let's begin with those in the majority who would turn to go onto the side track. Why would you do it? What would be your reason? Who's willing to volunteer a reason? Go ahead, stand up.
Because it can't be right to kill 5 people when you can only kill 1 person instead.
It wouldn't be right to kill 5 if you could kill 1 person instead. That's a good reason. That's a good reason. Who else? Does everybody agree with that reason? Go ahead.
Well, I was thinking it's the same reason on 9/11 with regard to people who flew the plane into the Pennsylvania field as heroes because they chose to kill the people in the plane and not kill more people in big buildings.
So the principle there was the same on 9/11. It's a tragic circumstance, but better to kill 1 and so that 5 can live. Is that the reason most of you have, those of you who would turn? Yes? Let's hear now from those in the minority, those who wouldn't turn. Yes?
Well, I think that's the same type of mentality that justifies genocide and totalitarianism. In order to save one type of race, you wipe out the other.
So what would you do in this case? You would, to avoid the horrors of genocide, you would crash into the 5 and kill them?
Presumably, yes.
You,
Yeah.
okay, who else? That's a brave answer. Thank you. Let's consider another trolley car case and see whether those of you in the majority want to adhere to the principle, better that 1 should die so that 5 should live. This time you're not the driver of the trolley car, you're an onlooker. You're standing on a bridge overlooking a trolley car track. And down the track comes a trolley car. At the end of the track are 5 workers. The brakes don't work. The trolley car is about to careen into the 5 and kill them. And now, you're not the driver. You really feel helpless until you notice, standing next to you, leaning over the bridge, is a very fat man. And you could give him a shove. He would fall over the bridge, onto the track, right in the way of the trolley car. He would die, but he would spare the 5. Now, how many would push the fat man over the bridge? Raise your hand. How many wouldn't? Most people wouldn't. Here's the obvious question. What became of the principle? Better to save 5 lives even if it means sacrificing 1. What became of the principle that almost everyone endorsed in the first case? I need to hear from someone who was in the majority in both cases. How do you explain the difference between the two? Yes?
The second one, I guess, involves an active choice of pushing the person down, which I guess that person himself would otherwise not have been involved in the situation at all. And so to choose on his behalf, I guess, to involve him in something that he otherwise would have escaped is, I guess, more than what you have in the first case, where the 3 parties, the driver and the 2 sets of workers are already, I guess, in the situation.
But the guy working, the one on the track off to the side, he didn't choose to sacrifice his life any more than the fat man did he?
That's true, but he was on the tracks. And
This guy was on the bridge. Go ahead, you can come back if you want. All right, it's a hard question. You did well, you did very well. It's a hard question. Who else can find a way of reconciling the reaction of the majority in these two cases? Yes?
Well, I guess in the first case where you have the one worker and the five, it's choice between those two, and you have to make a certain choice, and people are going to die because of the trolley car, not necessarily because of your direct actions. The trolley car is a runaway thing, and you're making a split-second choice, whereas pushing the fat man over is an actual act of murder on your part. You have control over that, whereas you may not have control over the trolley car. So I think it's a slightly different situation.
All right, who has a reply? Oh, that's good. Who has a way, who wants to reply? Is that a way out of this?
I don't think that's a very good reason, because you choose to, it's either way you have to choose who dies, because you either choose to turn and kill the person, which is an active conscious thought to turn, or you choose to push the fat man over, which is also an active conscious action. So either way you're making a choice.
Do you want to reply?
Well, I'm not really sure if that's the case. It just still seems kind of different, the act of actually pushing someone over onto the tracks and killing him. You are actually killing him yourself.
You're pushing him with your own hands.
You're pushing him. And that's different than steering something that is going to cause death into another. You know, it doesn't really sound right saying it now.
No, it's good. I'm up here. It's good. What's your name?
Andrew.
Andrew, let me ask you this question, Andrew.
Yes.
Suppose, standing on the bridge, next to the fat man, I didn't have to push him. Suppose he were standing over a trap door that I could open by turning a steering wheel like that. Would you turn?
For some reason, that still just seems more wrong.
Right?
I mean, maybe if you accidentally like leaned into the steering wheel or something like that. But, or say that the car is hurtling towards a switch that will drop the trap. Then I can agree with that.
Fair enough. It still seems wrong in a way that it doesn't seem wrong in the first case to turn, you say.
And in another way, I mean, in the first situation, you're involved directly with the situation. In the second one, you're an onlooker as well.
All right.
So you have the choice of becoming involved or not by pushing the fat man.
Let's forget for the moment about this case. That's good. Let's imagine a different case. This time you're a doctor in an emergency room, and 6 patients come to you. They've been in a terrible trolley car wreck. 5 of them sustain moderate injuries. 1 is severely injured. You could spend all day caring for the 1 severely injured victim, but in that time the 5 would die. Or you could look after the 5, restore them to health, but during that time the 1 severely injured person would die. How many would save the 5? Now as the doctor. How many would save the 1? Very few people. Just a handful of people. Same reason, I assume. 1 life versus 5? Now consider another doctor case. This time you're a transplant surgeon, and you have 5 patients, each in desperate need of an organ transplant in order to survive. 1 needs a heart, 1 a lung, 1 a kidney, 1 a liver, and the 5th, a pancreas. And you have no organ donors. You are about to see them die. And then it occurs to you that in the next room, there's a healthy guy who came in for a checkup. And he's... You like that? And he's taking a nap. You could go in very quietly, yank out the 5 organs, that person would die, but you could save the 5. How many would do it? Anyone? How many? Put your hands up if you would do it. Anyone in the balcony? You would? Be careful, don't lean over too much. What? How many wouldn't? All right, what do you say? Speak up in the balcony, you who would yank out the organs. Why?
I'd actually like to explore a slightly alternate possibility of just taking the one of the 5 who needs an organ, who dies first, using their 4 healthy organs to save the other 4.
That's a pretty good idea. That's a great idea, except for the fact that you just wrecked the philosophical point. Well, let's step back from these stories and these arguments to notice a couple of things about the way the arguments have begun to unfold. Certain moral principles have already begun to emerge from the discussions we've had. And let's consider what those moral principles look like. The first moral principle that emerged in the discussion said, the right thing to do, the moral thing to do, depends on the consequences that will result from your action. At the end of the day, better that 5 should live, even if 1 must die. That's an example of consequentialist moral reasoning. Consequentialist moral...
Very interesting. But the reason I want to is it right to kill 5? Or is it right to kill 1? Or is it right not to kill anybody? It's a question you need to answer though, because you are a judge. You will face situations like this, difficult situations, isn't it? No, but we need to deliver a judgment. We are called upon to precisely, clearly give our verdict. In an adversarial system, there is no balancing act. In the king's darbar, that used to be. I will make both happy. You can't have both people happy. Somebody is wrong, somebody is right. And there are, of course, grey areas when both are wrong. You need to say it. The clarity of your thought is very, very important. And that clarity of thought is the thought that comes to you when your mind is absolutely clear. So spare that time of the day or the night, or whichever time you have, to give a thought to the cases that are before you to pronounce a judgment. That's what I want to tell you. Thank you so much for this thing. We can do the next session. When do you want to do it? Want to do it now or after a break, or you're tired?
5 minutes break.
Yeah, let's do it. So let's start talking about this, Marriages and divorce. Now, there are various communities in Sikkim. We have the Hindus, we have the Bhutyas, we have the Lepchas, we have other communities, Christians, and till a point of time, as I see, historically, I've examined this for a period of time, and I find that in Sikkim, regarding divorces, a lot of women who have been subjected to all kinds of atrocities are not getting divorced because they don't know where to go, how to get about it, and we're not being able to guide them properly. So, and I heard this kind of stories from
different sections of the society, and I thought to myself that I must do some research and find out how to resolve this. And then my curiosity took the better of me, and I spent quite some time doing this research, and finally we have come with this compilation which I've handed over to you. It also has my opinion, a caveat. That opinion is mine, it's not a judgment to guide you. You have your own intelligent minds to understand what it is. It's a compilation of all the research that I have done and compiled it together for your benefit, so that you can make up your mind on your own and apply the law properly. Now, if you just look at this little thing that I have made, the law of marriages and divorce in Sikkim for different communities are a mix of codified laws and customary laws, and requires clarity, especially with regard to the scheduled tribes and Christians. Now, in 2006, this issue came up before the Supreme Court in this matter, Seema versus Ashwini Kumar, where it was directed that marriages of all persons who are citizens of India belonging to various religions should be registered compulsorily in their respective states where the marriages is solemnized. This direction came because of the problems faced by especially women in their marriages. Marriages are supposed to be made in heaven, it's supposed to be rocking, it's supposed to have, all kinds of good things, but sometimes it breaks, it fails. When it fails, you must bring an end to it, and if you do not get that kind of solution, it may be very difficult for a woman. And therefore, and in that situation, the Supreme Court felt that registration is very important, because once you register, you don't have to go around proving whether you're married or not. Now the Bhutias of Sikkim are facing precisely that situation. They've not been able to prove their marriages, and because of that, it's a lot of problem that they are facing, right? So this was thought about by the Supreme Court in 2006, judgment rendered in Seema versus Ashwini Kumar. Now, as you know, in Sikkim, many marriages are held customary. In the Nepali community, in the Bhutia community, in the Lepcha community, we do have our own customs, and we perform our marriages like that, isn't it? My marriage, for instance, I got married a long time ago, but I got registered much later, My son was quite big when I got registered. In fact, I was a senior advocate when I got registered my marriage. So, what I'm trying to tell you is, marriage is one thing, registration is something else. We can't put the two together. I think there's a lot of confusion about marriage and registration. What is a marriage? Right? Solemnization of marriage is something completely different than registration. Registration is a requirement of law, and because of that, we register ourselves. Okay? Give us some kind of a certificate that, of course, that we are married. My wife is married to me. I am married to my wife. We know, we feel it, but we still need a certificate, right? Why did I need a certificate? I'll tell you. I had to rush to Singapore because there was a bereavement in my wife's family, and my child was very young, and he didn't have a passport, so we needed to make a passport. We rushed to Calcutta. In Calcutta, when we went for making the passport, the Calcutta passport officer asked me that, how do I know he's your child? So he says, there's a birth certificate. So he says, but how do I know that he's your wife's child? So we are married and she has a passport as well. So the names are there in the birth certificate. But how do you know that you're married to each other? I didn't have a certificate. Now what do I do? So they told me that I should go and make an affidavit. So I went under a banyan tree to a lawyer who was sitting down under that tree with a typewriter, and he made a little affidavit and took a photograph of mine and my wife together, in which we were looking absolutely horrendous, because it was so hot, and then we were angry, and then it's one of the most terrible looking photographs that I have. Not that I'm good looking, but the fact of the matter is that we looked even worse. And then that photograph was taken, pasted on the affidavit, and then stamped, sealed, and then delivered to the passport officer. After that affidavit, he was satisfied, and the passport was issued at midnight, and I could fly to Singapore thereafter. Now, this is precisely the reason registration is made compulsory, and if you had that registration certificate, after that I came back to Sikkim and told my young colleagues to have my marriage registered. She went there to the registering authority and got us married and registered. So therefore I have a registration under the Hindu law. But I'm told, and this is why I requested you to be there, I'm told many Buddhist people from the scheduled tribe community are also registered under the Hindu law. Okay? And precisely because of that, a lot of petitions are being filed in your courts under the Hindu Act for Buddhists who are scheduled tribes. And then, I don't know what is happening there in your courts, but one such matter came before me and my senior colleague. And then I raised that issue. When we raised this issue, the petition was withdrawn. I don't know whether the divorce has happened or not, or whether you have granted divorce or not, but then if the divorce has not been granted, the person is suffering. And therefore, when I thought about it, I started feeling guilty of having raised the issue. But then I'm a judge. I'm supposed to speak the truth as far as law is concerned, right? And then I did. There needs to be a course correction according to me. And we need to do it fast and quick, because otherwise people will suffer. And that's the reason I embarked upon this research and got this compilation done. Now, if you look at historically, again, the cost of repetition, and especially for the young judges, in Sikkim, the sources of law, okay, you will have to know this, the sources of law are diverse. Unlike the other states, we have additional sources of law. Number one, we were a kingdom till 1975, and because we are a kingdom, we had our own laws, what we commonly know as the local laws or the old laws. We are so conscious about, to use a milder term, and very protective about our own laws, isn't it? There's a whole set of laws which have been passed as notifications, rules, regulation, all kinds of diverse language has been used to describe these laws. It is found in circulars, orders, notifications, rules, regulations, and the law department around the year 78, 79 compiled all these into booklets which we have available before in the law department. Of course, it is also there in our websites. These old laws, as you know, is protected under Article 371 FK of the Constitution of India, which says notwithstanding anything in the Constitution, all these laws are protected. So that's one source of law, the whole body of law which we need to understand and give effect to. But besides that, we became a part of India in 1975, and thereafter, after 1975, when we became part of India, all laws which were enacted in India after 1975, okay, which has been made applicable to Sikkim as well, because we are a part of the Indian Union as a state, those laws would be automatically applicable to us.
Article 371F also talks about those laws which prevailed and was alive in the rest of India prior to 1975 in different states, right, when we were still a kingdom. So to that, the prior media that has been found in Article 371F is that by a presidential notification it has to be brought in force. So all these old laws, like the ones which you talk about, the Christian Marriage Act, the Hindu Marriage Act 1955, 1877, Divorce Act 1869, Special Marriage Act 1954, are all those laws which comes in this category. So there must be a presidential notification bringing in this act to operate in Sikkim. Merely because it is printed by universal publication, it is in your desk, it doesn't become the law of the land. As I understand, the Divorce Act 1869 is still not made applicable in Sikkim as well, right? The others are brought into force in different dates. I have given these dates for your benefit in this, including the notifications. But around the 1930s, the Christian Marriage Act was brought into force by a notification issued by Rupnarayan. I think I've talked about Rupnarayan before. He was one of our first judges. He came from the erstwhile Pakistan now. He was there in Pakistan, I think. He was brought in, he was a Sindhi. He came here, he became the judicial secretary to the Chogyal, and thereafter he became the chief court judge, and then he became the chief judge for a long period of time, almost till 1954, and there are a whole body of orders and notifications which was issued during his time. So one of that brought in the Indian Christian Marriage Act 1872. Now if you look at the Indian Christian Marriage Act 1872, it talks about marriages, it talks about how marriages are to be solemnized, right? But it does not talk about divorce. So the way in is there, the way out is not there. We didn't think about it then, it seems. So the Divorce Act was never brought into force. The Christians can't get divorced in Sikkim. Therefore, that's the situation that has been created, strangely. But that is what a lot of people believe, right? Because the Divorce Act never came into place, right? Now, after the Christian Marriage Act came into place in 19 to provide for registration and solemnization of a form of marriage in Sikkim 1963. Now this is also part of this compilation, and if you read this compilation, that's right, you will find it is a copy of the Special Marriage Act 1954. The Special Marriage Act 1954 was brought into force in Sikkim just recently, but the Chogyal thought it fit to have this act in place in 1963 itself. Now if you look at our rules to provide for registration and solemnization of form of marriage in Sikkim 1963, you will find that this regulation, this rule is community neutral, it is religion neutral. Anybody who is in Sikkim could solemnize their marriage under these rules, act according to these rules, and also granted various grounds for divorce. If you look at those rules for grant for divorce, as you know, the Hindu Act provides us 3 or 4 grounds for divorce. But if you see this, there's a whole lot of grounds for divorce available under the rules to provide for registration and solemnization of form of marriages in Sikkim 1963. Now my personal knowledge about this goes so far as that after 63, marriage officers were appointed. I searched for it and found that in fact a notification was issued at that particular point of time, making a person as senior as the chief secretary to be the marriage officer. Page 33, if you look at it. It is, right? Now, this was a very wise thinking on the part of the Chokya to have brought this act, this rule together then, right? It gave some kind of semblance of sanity to this institution, right? It could, if you look at the law, marriages could be solemnized, there were marriage officers, there were registers, right? There were provision for divorce and all kinds of things. Let us look at it in a little more detail, and you will find this act at page 25. See? Condition relating to, have you got that? Conditions relating to solemnization of marriage, notice of intended marriage, marriage notice book and publication, objections, procedure for receipt of objection, power of the marriage officer in respect of inquiries, restitution of conjugal rights, judicial separation, divorce, and look at the grounds of divorce. A, B, C, D, E, F, G, H, I, J. Much larger than the Hindu Marriage Act. 13, then how the divorce petition is to be presented. Then 14, very important, no petition for divorce shall be presented to the Chief Magistrate's Court unless at the date of presentation of the petition 3 years have passed since the date of entering the certificate of marriage in the marriage certificate books. So therefore it was important that you register it under that, and if you did that, then divorce could have been granted. You notice that? There was also the concept of void marriages, voidable marriages, legitimacy of children of void and voidable marriages, courts to which petition should be made, duty of the court in passing decrees, very, very important issues dealt with in this. And the courts in Sikkim did administer this law for a long period of time till the Hindu law came in. Now when the Hindu law came in, the things had changed in Sikkim. I'm just talking about historical perspective, right? Things had changed in Sikkim, we had become a part of India, right? Indian laws were coming in, right? And so the Hindu law came in the year around 80s. In 1988, the Hindu Marriage Act 1955 was extended on 12/10/1988 and enforced on 1/5/1989. This act applied to Hindus. Now if you take this out, the Hindu Marriage Act, and this is why I wanted to draw the attention of the Law Secretary to this. The Hindu Marriage Act said in section 2, the act applies to any person who is a Hindu by religion in any of the forms of development, including so-and-so, or a follower of the Brahmo, so-and-so, so-and-so, so-and-so. B, to any person who is a Buddhist, Jain or Sikh by religion. Now, the Bhutia community professes, the Lepcha community professes the Buddhist thing. So, automatically the marriage, the registering authority at the DC's office started believing that the Hindu Marriage Act now, which has been made applicable in Sikkim, would be applicable to Buddhists. They were not wrong. Of course it is applicable to Buddhists. But what they did not do, and they didn't have that kind of acumen, legal acumen to read a little further, and if you go a little further to notwithstanding anything contained in subsection 1, nothing contained in this act shall apply to the members of the scheduled tribe. Now the Buddhists in Sikkim mostly are scheduled tribe. So the law says it is not applicable to scheduled tribe. The reason being scheduled tribes follow their customary law and practices, right? And therefore they should be spared of this. But we did not read this portion. So what happened? In the process from 1988 onwards, happily married Bhutias and Lepchas belonging to the scheduled tribe, professing Buddhism as their faith, went to get themselves registered. They went to the marriage officer. The marriage officer took out the Hindu law form, gave it to them. They happily filled it and then registered it. Now they are all registered. Between the period 88 till now, hundreds and hundreds, literally hundreds of Bhutias and Lepchas are registered under the Hindu law. Now, the matter does not end there. Some of these marriages, unfortunately, did not last. They broke down. Because they broke down, one of the parties sought for divorce. They went and approached your court. In your court, before approaching, the petition was filed by lawyers. Not filed by lawyers, but drafted by lawyers. So they saw the certificate of registration under the Hindu law. So they took out the Hindu law, as learned as they are, and then looked at the ground for divorce, made out precisely the ground for divorce, whether available or not, right? And then filed a petition under section 13 or whatever it is called, and filed it. Many of these judgments were rendered, divorce granted, happy, but one unfortunate case came to the High Court where I questioned this legality of this proceeding, and because of that, there's a chaos situation as I see it. The question which fell for my thinking is, do we allow this to continue, perpetuate an illegality that is happening? According to me, in my limited understanding, that would not be correct. We needed to course correct, right? So I raised the issue, and because we raised the issue, this issue is now required to be solved by you. Now, the question that comes before you each time, that issue of customary law being proved, the people, the Bhutias and Lepchas trying to prove customary law would not arise, because they would be registered under the 63 law, which provides for divorce, and you can't divorce. As far as the customary law is concerned, unfortunately in Sikkim, as I see it, we have not evolved, we have not developed customary practices in the manner that is required. Customary law, as you all know, it needs to be proved. Unlike statutory law, it is not in black and white. It is there in your practices. Who tells you about these practices? Your elders, community heads, your religious heads, right? Now, in a case like this, your marriages are customary practice. Let us understand how customary things happen. When we take, for example, the Buddhist customs, right? What happens in a marriage? A lot of customary things that happen, right? All that will give you evidence of what happened on that particular day, would be evidence of the fact that you got married on time. Now, how do you prove it? By getting witnesses, putting photographs, all kinds of evidence, documentary and otherwise, right? Registration is a subsequent thing, whether you register or not register. Until 2006, registration was not compulsory, we didn't bother about it, right? So it happened that way. The fact of the matter is that these customary practices prevail, it is continuing to prevail, and we are getting married under our customs, right? So people are coming over. Now there's a role even in the Bhutia community of the lamas, and we get the pig and gifts and all that happens, and all these are evidence. But this needs to be proved to show that you got to seek divorce, you need to prove that you're married. Now that's where the confusion comes between when the divorce is happening. It's so difficult because you go to a lawyer, the lawyer says, it's very difficult to prove this. So what happens, the clients get dissuaded. Oh my God, now, I will suffer 3 years, 4 years, 5 years of all this, Now, if you see, I have not seen a single judgment on customary practices. Just one or two. But it is not happening. It is not happening in the district judiciary. It is not happening in the High Court. It is not happening. Right? Customary practices are very, very rare as I see it. But then it is prevailing in issues like marriages and divorce. It is happening. Now, if customarily, if you are getting married, how do you get a divorce? Is a question I wanted to ask. How do you get it?
Technically, it was going through this, and then the only solution like hers also logic, she's registered under the EU marriage. So the only solution was to prove it the customary way. And then logic, when I was asking how do we do that, logic, as per the customs, logic, when the groom comes to, during the wedding, when the groom comes to the bride's house, so that entire bandwagon, like the uncles and the cousins, whoever were involved, they are required to again have a sitting. They require those people only, and then they are supposed to have this milakati.
And that is the way of divorce.
Yes.
Customary.
Yes.
Isn't it? Yes. Now, if marriage is happening customary, divorce also can happen customary. Yes. But the evolution of this custom has not happened, so we are confused. So we are in that cusp, as I see. Authenticate the fact that in writing, how do you get it otherwise? Right? Because in customary practices, right, there's no question of documentation. The custom meant that itself. Therefore, there is a difference between customary law and statutory law. Whereas statutory law puts everything in black and white, customary practices are basically what prevails over a long period of time and practice over a period of time and told to you from father to son to grandson to thereafter and continue. Right? So this confusion has to be taken out as far as divorces are concerned. But to get out of all this, from 2006 onwards, it has become compulsory for everybody to be registered. Are we clear about that? SEMA says that. Then, during SEMA's time, the Supreme Court asked all the states to tell them whether it is compulsory registrable, or if not, to make it compulsory registrable in all your states. As far as Sikkim is concerned, we issue a notification, and that is there at page 54. Now let's read this notification. It's dated 9/8/2007. SEMA judgment is of 2006. In 2007, in exercise of the powers conferred by Rule 34 of the rules to provide for registration and solemnization of a form of marriage in Sikkim, issued with a Home Department, Government of Sikkim, notification number so and so of 63, it is hereby notified that henceforth marriages of all who are citizens of India solemnized within the state of Sikkim, belonging to various religions, shall be compulsorily registrable with the marriage officer of the respective district within whose jurisdiction such marriages are solemnized. I have not seen a clearer notification than this. All religion, including Buddhists, Bhutias, Lepchas, Christians, Hindus, everybody must be compulsorily registered under this. From 2007 it is made compulsory registered. How many of us knew about this notification? Very few. That's why I asked you to be here. why I've been not highlighting this. Why is it that even after 2007, people are registering marriages under various other acts? If your intention was to ensure that all registration had to happen under the 63 rules, why is it that it is not happening in the matter? The reason for the confusion which she pointed out just now is this. Look at, I don't know, she's talking about a relative. I don't know how old she is, but must be relatively new. I don't know when was the marriage?
It's 15 years. They were married.
15 years means how much? Which year? Right? This is after 2007. So the law is very clear. It should have been registered here.
They registered under Indian Act.
That's right. Somewhere we're going horribly wrong in Sikkim. If this was your intention, then we should have all been registered under this. No problems at all. Now, if a bhutia.
So what we are doing in the non-district lordship, I had this compiled as in the registration rules, and then I gave it to the DC as well as the SDM. And during those our programs lordship, like we talk about lordship, we inform the public also to have it registered lordship under this rule. If you are a Buddhist and a scheduled tribe lordship.
Now, according to me, it needs much more than that. According to me, the government must act for the whole of the state of Sikkim and ensure that the things are done in the manner you have chosen to. By issuing this notification, you made your intention very clear. All registration must happen in the under the 63 rules. The confusion is, and that is a question you must ask yourself before you do the Christian law. But it's not made common. The provision for registration is there. If you see the Hindu Marriage Act, Section 8, right? You have brought in the Hindu Marriage Act, registration is there in Sikkim, right? Now, by the 2017 7 notification, you made the marriages of Hindus as well registrable under the 63 law. So what happens to the registration? There will be double registration. So I think the thought was, no matter what, okay, let's put it in one book. Let us all register this Indian citizens solemnizing their wedding in Sikkim in the 63. Whether it is registrable or could be registered under the Christian Marriage Act or the Hindu Marriage Act, let's register them here. As far as the Buddhists are concerned, there are customary laws and practices which is very difficult, so therefore let them bring them under fold of the statutory laws and bring them here. That seems to be the intention, and according to me, that's a good intention, right? So, but I think we need to give effect to it. If you don't give effect to it, these are the problems that you will create.
Also, when the date of the registration would be, because there are many people who want divorce, and under the rules, it is said that you have to be registered for a period of 3 years or something for registration. Now it's
then according to me, let us say, I don't know, my interpretation, I myself and my wife went to the registering authority in the year 2007, right? I sought for my registration in 2007. They issued me a certificate under the Christian law. Now, is it my fault that I am a Hindu? So now they have to rectify to do this, otherwise it will be chaos. But I think this is the only way out as I see it.
Like a format that under this act your marriage is there like a format?
This you will have to study. I have now given you all the resource available before me. Please look at it, go through it properly and come to your conclusions.
In the manner I'm facing in non-district lordship, we have the Zumsa's lordship. So even they then they just say, Mr. A Lachumpa is married to Miss B Lachumpa, and this is the marriage certificate. Now it doesn't say under which law.
Well, as I see it, you have to balance it out. You know, if you look strictly by our standards of understanding law, then Jumsa's act would be illegal, isn't it? But we need to balance it out. According to me, the Bhutias and Lepchas, the Bhutias, the Lachunpas and the Lachunpas, often they come from scheduled tribe areas, they're scheduled tribes, they follow customary practice. If the Jumsa gave a certificate as the Pipon or whatever to basically give as proof of marriage or what they call, or the customary marriage that they had, that's correct. I don't think it's a problem. One can recognize that. Legally, it is not recognizable. You have to still say that it is a customary divorce or customary marriage, right? And this is proof of the fact that it was done customary. To that extent, the Jumsa certificate would be. Otherwise, legally, by any standards of any law, that is not. Because 63 law came into place in 63. You would have done it in 63, right?
So under
Create
what
law.
provision?
Sorry?
Under what provision they will
That's
find?
what
Who?
what
Certificate is given.
That's the problem I'm facing.
Sorry, I couldn't understand.
If certificate is given by Jumsa, then under what provision they will file?
Who?
Litigant.
The litigant. The litigant will file for divorce. As I said, at the cost of repeat, I just explained to Jamin right now that she said file a declaratory suit. In a customary, this is where we need to understand what is custom. I think we need to do a little bit more deliberation on customs. What is custom? हामीले आफ्नो कम्युनिटी भित्र जे प्र्याक्टिस गर्दैछौँ त्यसलाई को कस्टम भन्छ लिखित रूपको कस्टम भन्दैन हैन तपाईको कम्युनिटीमा एउटा प्र्याक्टिस त्यो मेरो कम्युनिटीमा नेपालीको हेर्यो भने पनि है तपाई यु बिलोङ टु अ डिफरेन्ट कम्युनिटी आई बिलोङ टु अ डिफरेन्ट कम्युनिटी right we have our own peculiar practices that is custom now is that as far as the law commission of Sikkim the Nepali customs are there it's a full report is there right now is this statutory law no it is not or if you look at the inside of this okay it's a question answer format various community leaders have been given questions and they've answered they've all compiled these together and what is common, they have put it up as customary practices of the Nepali communities. That is, see if you see the details in the index, you will find Baun, Brahmin, Bhujel, Chetri, Damai, Darji, Kurung, Jogdi, Kami, Limbu, Subba, Maji, Mangar, Pradhan, Newar, Rai, Sarki, Suar, Tamil. Right? So all the Nepali community questions and answers are, let's say, हाम्रो practice the Nepali को practiceहरु यहाँनिर गरेको छ but you can't go and use this as a statute book and say this is like this so according to this it is like you know proper reports but draft reports are available it will just I'm giving this to you to give you an insight into how that this kind of practices does prevail. It's just that we are new generation, so we are not aware. We come and sit in cities and forget our customs, you know. But customs at one point of time, according to me, must give way, and you know we have to abide by statutory laws because that will ultimately benefit the society. That's what I feel. That's my personal opinion, though. But yes, if you don't want to prove customary practices in your court, then you will have to guide the lawyers and the litigants to bring in evidence to prove it. Customary practices can be best proved by village elders, by people who are known to, people who have studied it, people who have written books on it. Books can be exhibited, articles can be exhibited, you know, people who wrote about it, who discussed it, can be brought as evidence, and village elders, community heads, religious heads, they can be brought and proved. So, as I said, marriages, customary marriage can be proved only that way. Customary कसरी हुन्छ? लिखित रूपमा हुँदैन, सर्टिफिकेट हुँदैन, रेजिस्ट्रेसन हुँदैन। घरमा तपाईको घरमा के हुन्छ? बाजेले बोलाउँछ, है? आफ्नो आफन्तहरूलाई बोलाउँछ, रिलिजियस हेड्सहरूलाई बोलाउँछ, छिमेकीहरूलाई बोलाउँछ, है? त्यहाँदेखि सर्टन रिचुअल्सहरू हामी पर्फर्म गर्छौँ, मान्छेले आएर हेर्छ, है? त्यहाँदेखि एल्डर्सहरूले ब्लेसिङ दिन्छ. All those who participated become witnesses to prove it. Now, divorce कसरी गर्ने भन्दाखेरि, when she rightly pointed out, divorce also customarily happened in that manner. पहिला त त्यस्तो statutory lawहरू थिएन, हैन? So, in certain communities like the Bhutias and Lepchas, it still prevails, right? We are now governed by our Hindu laws, right? It's applicable to you. So, as far as Nepali community is concerned, much of the customary is gone because we are now in the statutory laws. In 63, that is what I said, even for the Bhutias and Lepchas, the king thought it fit in 63 that now it is time to migrate into statutory laws. So let us make a law which is, if you see the Special Marriage Act, that was also...
All the marriages, whether it is admission or
That's right.
That's right. Everything has to be registered under the rules of 1961. But my question is, whether it will be proper for the state government to ask the people to register only under this one?
You've already said it in 2007.
No, but that is what my query is. Because there is a registration provision in Hindu law also, Christian Marriage Act also. Whether it will be proper for us to say that, no, you only marry...
But you have already said it. What is it? I can't understand you.
That is there, but whether that would be a proper thing to do also. Because if I want to register my marriage under the Hindu Marriage Act also, then whether it would be proper for someone to tell me...
Then something has to be done with the 2007 notification. I am not the government's thinker. You got to think. You understand? Specified in Rule 10 as for particulars relating to marriage entered. So if you read both these provisions, the Section 8 as well as the rules, it is not compulsory. If you desire it, go and do it. That's what it says. Right? Therefore, a lot of marriages took place, but registration did not happen because it was not made compulsory at all. The Act did not make it compulsory. Now, the one thing which could have been done by the Parliament is amended through Section 8 and made it compulsory, but that has not been done, isn't it? It remains as it is. The rules which you have framed, this is in 1991, that also says may, right? So it was never made compulsory. So although the provision for registration is there, right, it was not compulsory. Because it was not compulsory in 2007, the government thought it fit to make it compulsory under the 60. That is my view. But I'm not the wisdom of the government. You are the wisdom of the government. Please give your opinion and take a call on it. That's what I'm saying.
We cannot take together, and that dispute is going on for almost 10 years. Now, ultimately, they come to the court with the petition, and the court said that since you are not governed by the Hindu law, we cannot give you divorce under this law. Now, whether now they cannot go back, and husband and wife are not in talking terms, even inside the courtroom.
That's the human problem.
Living separately.
The other one is a legal problem.
Yeah. Plus, legal problem here is now, if they don't want to go for the customary divorce, because that is quite a taxing thing to do. Now, they cannot come before the registering authority together and register their marriage under 63 rules also. Because they are not in documents. But if they get married...
But that's their problem, not yours.
No, but now how they will go for the divorce again now?
You're not asking your opinion for them, are you?
That was a particular situation that arose in my court was involved.
No, but I'm thinking like this. Okay. So why would we do this?
In this kind of situation, as far as I know, it has to be first registered
registration happened by whom? Who did the registration? The authority. The authority. So are you going to penalize the couple because of the fault of your registering authority?
In this case,
I am thinking now.
They have not never registered their marriage. They are not registered their marriage under any of the rules.
Then you can't do such kind of somersault innovation. Then they will have to go through the customary practice and do it, isn't it? This is the problem. You see, therefore, people who are educated, who are moving forward, they are moving ahead, right? But if you are subscribing to certain customary practices, then it is a difficult task. You need to go through it. That's right. So therefore, even the Constitution recognized it. The Constitution recognized it. The Hindu law recognized it. The Hindu law said that if it is scheduled tribe, right, then the customary practice will prevail. But if customary practice, but that is available in customary practices as well, I'm sure, and it would be available in the statutory. So if it is there in the statutory practice, why don't you take the easy way out? That is the option given, isn't it? So we have limited choice in cases like what you say. It has to be proved customary. You will have to go into.
Registered but under wrong.
Just switch on that.
Divorce with this. We don't have a standard setup. How, under what ground divorce?
That's what you're right. If you see this question and answer format. Here. Let's go through this.
Marriage certificate has been issued under the Hindu law. You can convert it to have been issued under this law.
By an act of the state, yes, you can. You are the
with that
with
that retrospective effect.
Issue a notification. You rectify the error that you committed.
Yes,
your officers have been creating havoc in this country, state. They don't listen to you. I've been going to, as a lawyer I went. I'll tell you instance. This form, this whole concept, vendor law. You would give this thing and then we would sign on the dotted line. Right? But those were different times. Now there are lawyers and there are judges. We didn't have lawyers, we didn't have judges there. We had executive functioning as judges. Things have changed. We need to change according to times. No sakyo bhane. Lay people are accused. यहाँ sign गरे sign. Form दिइरहेको चाहिँ हेर्दाखेरि मजाको छ म कानुनहरु माथि लेखेको छ हैन सेक्सनहरु कोड गरेको छ तर्सिहाल्छ त अन्त लेखेको छ साइन गर्दैछ हामी लर्नेड लयर जजेसहरु त साइन गर्दैछौँ अरु कुरा के हो So this course correct. I think judges also need to apply their mind. The idea is to give relief. If there is a valid ground for divorce, reconciliation is very important. Ask them to reconcile. If you can sustain and save their marriage, very good. But if you can't, if it is a chronic case, then you can't tell them to go back because the provision of law is this and that and go back. There's nothing I can do. When the court raises their hands up, that's the end of justice, isn't it? I would rather that you do a wrong and do justice, and then we will course correct it later on, than not to do anything at all and sit and say, no, go for that, return. That's not the right thing to do. Not to apply Guru for it, justice the Dinu for it. But I think a lot of thinking is required by, I think you need to deliberate with, and course correct this. It's very important. Now see, look at I have not talked about the Christian Marriage Act. Look at the Christian Marriage Act. The Christian marriage allows registration, and if you see this, start from chapter 2. you have it? No, I think it is better that what you do is you take this. You don't, you have it? The definitions are not there, but from Section 4, look at that. Section 4 in Special Marriage Act is condition relating to solemnization of special marriages. You have it? Yes. And look at page 25 of the compilation. It's exactly the same thing. Right? So from there onwards, if you see, notice of indented marriage, all that. Everything is there. Almost verbatim. So if the 63 rules have been in place from 63 and in 2007 you made it compulsory to all marriages in Sikkim to be compulsorily registered under the 63 Act. Now by bringing in the Special Marriage Act, what do you do? What does the citizen do? Because like the 63 rules, it also provides for registration, it also provides for marriage, it also provides for thing. So where does the citizen go to? So you need to now do something, according to me, which will take away this confusion. If we judges are confused, imagine the lady. I don't know what to do now. The Special Marriage Act 1954, if you look at it, talks about all aspects, including registration, solemnization, conditions, reports. Where do people run to? Are they going to register under the Special Marriage Act, under the 63 regulation? If we are registering in the city, what is the purpose of the Special Marriage Act 1954? I'm hugely confused. I think the government needs to take a call on all these aspects and make it clear to the citizens. That's the request I have. That's why I requested you to come in.
Enough of marriage, no, we need divorce law.
As of now, as I see, this marriage and divorce is a huge amount of confusion. Multiple acts, overlayer. Indian Christian Marriage Act, the Hindu Marriage Act, Special Marriage Act, all talks about registration.
We are not talking about the Muslim marriage.
We didn't think about it, just imagine. We thought about Christian Marriage Act in 1930, but we didn't think about Hindu Marriage Act in 1980. So, I would believe that between this period, the law of customary practices could have evolved among the Nepali community as well as in the Buddha lecture community. But it did not, strangely. In spite of the effort of the Law Commission and all that, there are certain renditions by the High Court with regard to, I think, Justice Bhattacharya's judgments and all that. But there were some various articles published by him. But in spite of that, I don't think there has been any development at all as far as customary practices. How many cases come to you in your district that involves customary practices? The other thing which I, by the by, I wanted to tell you is, things you know as judges, you know the law. I understand that you know the law. You know, and therefore you apply the law in petitions. You know. But what I see is you applied the law in many cases by the name in the title. So if it's a Nepali name, you apply the Hindu law. If it's a Christian name, you apply the Christian law. I have a driver, his name is John, but he's a Hindu. As I see it, neither the affidavit nor the pleadings talk about the community they belong to, the religious practice they follow. How did you, by your imagination, render judgment under the Hindu? These are live cases which has come before me. So I think that we need to give it a little more thought. By merely because you know the law, you can't just apply it. The facts have to come from there. The facts have to be very clear. You need to be clear that what a particular person belongs to that community and therefore that law will be applicable. Isn't it? So be a little mindful of that. The other thing which I wanted to again tell you is, you know, and I've said this many times, you apply the law the moment the law is brought before you. But many of these laws are not applicable, as I said. The pre-1975 law, if the president's notification is not there, then you can't apply it. But you apply it, I see. In many of the Sikkim laws, it says that it will come into force on the day a notification is issued by the government. But there is no attempt to find out whether the notification is issued. You have applied it because it is in the Gazette. So the presumption is, since it is printed and published in the Gazette, the law is applicable. That's a wrong thing to do. Because sometimes they enact the law, but they don't enforce it for n number of reasons. It's a policy decision of the government. You need to respect that. Right? The one example that comes to my mind is that law which you all came out with, the Succession Act. Many of your courts applied it. So be a little more careful in, you understand what I'm trying to say? If you see, when you read an act, in the very beginning, you will find, take for example, the Special Marriage Act. The Special Marriage Act says, it shall come into force on such date as the central government may, by notification in the official gazette, appoint. So there has to be a separate notification for that. But what we do is we don't read this because your attention is not drawn by the learned counsel on this. They draw your attention to the relevant portion, right? And they say, please apply this law. You read the law, it is in their act, universal, everybody knows about it. So you apply it without considering whether 54 Act has been brought into force. So be very, very careful when it happens accidentally. Most of the time it happens accidentally. Sometimes you are misled, right? Either way you are going wrong. So as judges we need to be a little careful. Okay? These are the couple of things that I wanted to tell you. Yes.
Suppose
outside Sikkim,
residing in Sikkim, and this new law is not extended for the state of Sikkim, whether that person can file a suit or any petition under the new law?
No, of course not. You cannot. How can you do that?
Because he is per se a Hindu.
So you can't. It has to be applicable law. We have to follow the law of the state, isn't it? 371F very clearly says that. So without a presidential notification, let us say we wanted to, let us say a Christian, right? A Christian coming from West Bengal wanted to divorce in Sikkim, reside in Sikkim, right, under the Divorce Act. They can't. How do you apply the law? You cannot apply the law which is not applicable, not enforced in Sikkim. It's very clear.
It talks about the extension within certain geographical boundaries.
That's right. If it is enforced in Sikkim, yes. If it is not enforced, it's very clear. The answer that you seek is it enforced in Sikkim? Is it applicable in Sikkim? If it is not enforced, you can't apply. We are interpreters of the law, not creators of the law.
Hindu by birth, so he should have carried.
Of course,
that
he may be
law.
Hindu by birth.
It's a personal law. He should have carried it.
Right? If you can bring it from West Bengal, so you can bring it from UK or the United States of America or Finland. I don't think that would be something. Any questions? Anything that we need to discuss? Of people that you.
When I read my own judgment, which I passed in 2009-10, I find all the things very funny.
I have a bloated ego, so when I read my judgments, I'm very proud. A couple of these data shatters.
I wish that nobody should read those judgments.
But there should be a constant endeavor from all of us to improve ourselves, better ourselves. And as a young judge, you are very impressive. So sometimes I get impressed by one style of judgment, then I get impressed by another style of judgment, then I read the third, and I get impressed by that, and then I don't know what's my style. So I think we need to evolve our own style of reading things. It takes time, but we need to evolve. But that clarity is absolutely essential. Clarity of the facts, clarity of the law, and your analysis, reasoning.
We have come to the end of today's session. May I now request Learned Director Sir to kindly propose the vote of thanks. Please, sir.
Now we have come to the logical culmination of satisfying and successful two sessions of today's program devoted to the justice delivery system of our state by this institute. In this occasion, I, on behalf of Sikkim Judicial Academy, it is my unique privilege to extend earnest gratitude to his lordship and feel extremely grateful for showering and sharing precious and most valuable time with all of us here with experience and knowledge on the topics of two sessions of today's program. By clarifying the n number of issues involved on today's topic, which, as for me, perhaps, till today confined in the pages of books without having life and soul till today. And I once again feel it that whatever deliberation His Lordship has made today on the various topics is worthy of appreciation, especially in this 21st century under the regime of information technology for better quality, greater efficiency and higher productivity in judicial administration. And I hope and expect that whatever deliberations well, dealings, those matters in their respective court in days to come, I, on behalf of Sikkim Judicial Academy and all officers once again would like to offer sincere gratitude to His Lordship for this wonderful and remarkable contribution made to all of us here today. And I equally would like to congratulate all officers present here for successfully participating in this particular program, and would like to offer sincere thanks to each and everyone for sharing your precious time. By enhancing the elegance of this program with esteemed presence and active participation, I once again would like to offer sincere thanks to all officers. Lastly, I must offer my sincere thanks to all staff members of Sikkim Judicial Academy, GT Catering Enterprise, these services, photographer, videographer from New Vision, who really not only work behind the screen, or providing their inflicting dedication to ease and provide continued atmosphere in this hall, but they have also put in their dedicated services to make substantially this program a great success. Lastly, I would like to request all officers to kindly join us for photo session in ground floor, and kindly proceed to banquet hall for lunch. Now, with the permission of His Lordship, I would like to declare the end of today's session. Thank you all.